Good morning, everyone, and welcome to the ISDA webinar, Cross-Border Representation on ISDA Amend. At this time, all participants are in a listen-only mode. Should you need assistance, you may signal a conference specialist by pressing the star key followed by 0. After today's presentation, there will be an opportunity for you to ask questions. To ask a question, you may press star and then 1. To withdraw your question, you may press star and then 2. Please note that today's event is being recorded. At this time, I'd like to turn the conference call over to Ms. Catherine Darris of ISDA. Please go ahead.
Thank you. Hi, welcome everyone. The goal of the webinar today is we are going to discuss, first of all, the regulatory background to our cross-border swaps representation letter. We'll go through the letter itself, the representations in the letter, and then we will discuss the ISDA Amend facility that will be available later this month to collect the representations. So I'm joined by Jeff Robbins, a partner at Cadwalader, and Richard Wong from Markit. Jeff will discuss the regulatory background and the representation letter, and then we'll turn it over to Rich to discuss the ISDA Amend offering. The presentation will be available on ISDA's website, a recording of the presentation later today, as well as the slide presentation. So with that, I will turn over to Jeff.
Good morning, everybody. Hope you're well. Happy Friday the 13th. I'm tempted to say for many of you it's probably seemed like Friday the 13th many times over the course of the last couple of months. But if there are any regulators in the room, I didn't actually say that. We're here to help sort of you by providing tools to manage the process of transition into cross-border application of the CFTC's regulations. We hope you'll find these tools helpful and usable. I'm going to go through the slide presentation more or less in the order Catherine just laid out, with a little bit of regulatory background first, and then we'll dive into the letter. As an initial comment, let me just note up front that the publication, the cross-border representation letter that ISDA has provided, is a representation letter that's a standardized letter that's available for bilateral or really kind of one-way delivery. It is not a protocol. When many people think of ISDA, they think of ISDA protocols, unlike the first two Dodd-Frank protocols and the prime brokerage protocol and the EMIR protocols. This is not a protocol that requires adherence. It's a single document representation letter that can be delivered bilaterally to counterparties. And we did that for a few reasons. When we began this project, we recognized early that the basic requirements for the industry in relation to the CFTC's interpretive guidance was to provide and receive representations, some of which might be tailored to a particular counterparty depending on the relationship with that counterparty. So when we weighed the pros and cons of different approaches, we recognized that what we really needed was one, to try to provide assistance through standardizing documentation so that folks wouldn't be drafting stuff whole cloth and negotiating and renegotiating them every time. And then second, because of the need to potentially customize what you deliver to a counterparty, the use of a directed document like a letter or a questionnaire, as we've done in previous protocols, with the potential to deliver those on ISDA Amend. And we recognized that the ISDA Amend functionality would allow us to do that with a rep letter without needing to go through the process of adherence and doing additional adherence letters and the rest. And since there aren't any full-blown kind of agreements that are required, we didn't think that the time and given the very small time band that we have as an industry to adapt the CFTC interpretive guidance, we didn't think the time that would go into an adherence full-blown protocol agreement was going to be time best spent. So again, it is a bilateral letter, but it can be delivered on ISDA Amend in virtually the same way that a party would have delivered a questionnaire on ISDA Amend in connection with either of the two Dodd-Frank protocols. Oops. Okay, so going into the regulatory background, I'll try to be reasonably brief on the background. Why are these cross-border representations needed? The origin of all of this is Section 2I of the Commodity Exchange Act, which provides that provisions under the Act and the regulations under the Act adopted by the CFTC don't apply to activities outside the United States unless they have a direct and significant connection with activities in or effect on commerce in the United States or are evasive of a CFTC anti-evasion rule. That sort of statutory language has been out there since the adoption of Dodd-Frank. As we know, it was only in July of this year that the CFTC published final guidance interpreting their view of the breadth of their jurisdiction under Section 2I and indicating to market participants when the CFTC would generally expect to assert jurisdiction over a swap counterparty or a swap transaction. Now, two pieces of color commentary on that. First, if you look at the interpretive guidance itself, what you'll see is effectively the CFTC took the broadest or close to the broadest possible reading of their jurisdiction under 2I, with kind of an interesting reference to sort of Supreme Court constitutional case buffs out there, to the old case of Wickersham v. Filburn, and activities that on an aggregate basis could have an effect on the U.S. marketplace. And then having established a very, very broad scope for their asserted jurisdiction, they basically scaled back what they said they intend to do by reference to principles of comity and recognition of interest in other non-U.S. jurisdictions. That makes for a fairly complicated set of rules, I'll say in quotes, in terms of when CFTC jurisdiction applies and when it doesn't. It also makes for a lot of color commentary by the CFTC in the release as to how to interpret their various principles. And so it is a little bit of a soft ground on top of which to try to draft interpretations, and one of the or draft representations, and one of the challenges in putting this together in the project was sort of how to kind of thread the needle of creating representations that people can use and can make while sort of covering the territory as described by the CFTC. And in the same vein, I'll also note it is interpretive guidance, not a rulemaking by the CFTC. The CFTC basically says that up front in the guidance, and as a consequence of that, they really don't set bright line tests for a lot of their guidance. They literally they say up front that the interpretive guidance is how they would ordinarily expect to apply their rules, but there is a lot of room left for discretion in other in fact patterns that the CFTC has not anticipated. And so again, when you look at it, you get some reasonably hard definitions, but in a lot of cases you get lists of factors that go into the CFTC's considerations rather than sort of bright line tests. Okay, so the interpretive guidance provides guidance as to when the CFTC swap regulations will apply in a number of different kinds of scenarios, generally where one of the parties is outside of the United States. And the basic categories that are reflected in the letter are up here on the screen. It's swap dealers based outside of the United States, and swap transactions with those kinds of swap dealers. I'll note for U.S. swap dealers, the cross-border guidance is generally not particularly applicable, except that when U.S. swap dealers report swaps to a swap data repository, they are, as one of the obligated under the Part 45 rules, and it is one of the fields that they're supposed to report whether the counterparty is a U.S. person or not. So, status may be important to your U.S. swap dealer counterparties for purposes of reporting obligations, but aside from reporting obligations, their duties are generally not dictated by how a counterparty lines up according to the interpretive guidance. For non-U.S. swap dealers, the interpretive guidance basically does provide the CFTC roadmap as to when substantive requirements of various sorts will apply. And then for non-swap dealer counterparties, there are a number of different kinds of categories, including non-U.S. branches of U.S. swap dealer banks, and there's also some discussion on the flip side of a U.S. branch of a non-U.S. swap dealer bank. Swap transactions involving non-U.S. persons who are guaranteed by U.S. persons, and we'll talk about what it means to be guaranteed by a U.S. person in a little bit. And then swap transactions with non-U.S. persons who are so-called affiliate conduits of U.S. persons. Substantively, I think you can think of the interpretive guidance as driving sort of the answers to two sets of questions. For non-U.S. swap dealers and their counterparties, the guidance tells you when the CFTC will assert a jurisdiction and which of their rules they apply. In particular, to what extent the so-called transaction level requirements will apply. Although there are a couple of different so-called entity level requirements that are also applied based on the status of the counterparty as described under the interpretive guidance. So that basically goes to external business conduct rules, relationship documentation requirements, trade reporting requirements, clearing, CEF trading, mandatory CEF trading, mandatory clearing, and portfolio reconciliation. And I note entity level requirements on the slide just to sort of highlight to people that SDR reporting is actually an entity level requirement under the CFTC's guidance rather than a transaction level requirement. And that distinction becomes important when non-U.S. persons face non-U.S. swap dealers, as we'll talk about in a second, but basically because non-U.S. swap dealers always have to comply with swap dealer reporting requirements, except where there is an affirmative recognition by the CFTC of comparable law in a non-U.S. jurisdiction, a so-called substituted compliance determination. Okay, so that's for the swap dealers, and then for other non-U.S. persons, the guidance basically tells you the CFTC's view on when a more limited set of their rules will apply, even if there's not a swap dealer on either side, including mandatory clearing, mandatory CEF trading, and again, trade reporting to a U.S. swap data repository. Also, and equally importantly, it establishes when a swap needs to be counted by a non-U.S. person that may be doing some de minimis dealing for purposes of the swap dealer registration requirements and the registration thresholds, as well as for MSP registration thresholds. So, the U.S. person reps are of significance both when facing or transacting with a swap dealer, and frankly, when transacting with a non-swap dealer who is not a U.S. person. And in connection with both of those groups, the interpretive guidance then drives what documentation requirements may apply to the pair of counterparties in order to establish compliance with the relevant set of rules, including those addressed by the two ISDA protocols. So, for example, a non-U.S. swap dealer who's facing a U.S. person who the interpretive guidance has newly identified as a U.S. person who didn't think they were a U.S. person before the interpretive guidance came out, those parties will have documentation requirements that will basically be the full suite, including both ISDA protocols potentially or bilateral alternatives to those protocols. By contrast, a non-U.S. swap dealer facing a non-U.S. person counterparty, in that pairing, transaction level requirements generally do not apply. Entity level requirements, as I mentioned a moment ago, still do apply, including swap data reporting. So, generally one might conclude that you wouldn't need to be in the March protocol or Protocol 2.0. You generally would not need the agreement in the August 2012 protocol. However, your counterparty might very well request that you provide consent to reporting to an SDR in order to deal with possible confidentiality restrictions under applicable law. Okay, so again, the scenarios addressed by the interpretive guidance depend on the status of each party to a transaction. Both parties need to be taken into account in order to establish which CFTC regulations will apply. Certain of the status types can readily be determined by reasonably public information, but certain of the status types cannot and require information that must be effectively represented or notified by one party to the other, and that's why we have the letter. Many provisions of the guidance, including the CFTC's interpretation of who qualifies as a so-called U.S. person, go into effect on October 9th. So that is a big target date for folks in terms of getting these representation letters completed. Again, though, note that that's only one step in the process. If you are a U.S. person or do have Dodd-Frank compliance requirements with the counterparty, even if you're not a U.S. person, there may be a document follow-up that will need to be put in place after your status is established. So October 9th, although it's a regulatory date, you shouldn't think of it as a due date. These representations should be provided, as soon as possible. Also, again, I'll note. In one instance, October 9th isn't the earliest date. Real-time reporting requirements, which basically means reporting to a swap data repository for purposes of public dissemination of information. Those requirements go into effect on September 30th, where the parties involve a non-U.S. swap dealer who's trading with a non-U.S. counterparty who's guaranteed by U.S. persons. And similarly, I believe, for non-U.S. branches of U.S. banks. So there is a September 30th deadline for purposes of trading, and that also requires, information provided in this letter. Okay, so turning to the letter, first I note the paper version of the letter has been published and is available for people to use now. It was published on August 19th. It's on ISDA's website. And in particular, for parties who will not be able to use the ISDA Amend platform to exchange data, and that would really be, sort of buy-side to buy-side parties where neither of the parties is a subscriber to ISDA Amend. The paper version is really the version you should look to exchange these representations. The ISDA Amend platform is being rushed to completion. I'll let Rich Wong, who's with me here, speak to this later, but I believe the target date is currently September 20th. Rich, September 20th?
Yeah, we're releasing it on September 20th, but the user access will be able to get on September 21st to start using that process.
Right. And so that will be available then, and will be primarily available for providing representations to swap dealers, MSPs, and other large sort of sell-side institutions that have become paid subscribers to ISDA Amend. All right. So the structure of the letter. The letter contains a series of what you could think of as being yes/no representations. That are organized in a logical hierarchy to sort of provide a flow as you go through the letter with instructions as you go through to know which pairs you should address, and is designed to provide effectively all of the information required to locate a person for purposes of the interpretive guidance, meaning, are they a U.S. person, are they not a U.S. person, etc. I say effectively all of the information. We didn't include representations as to whether a party is a swap dealer or an MSP because that information is basically already publicly available. Anybody can go onto the NFA's website, download an Excel spreadsheet that has the name and the jurisdiction of all registered swap dealers and MSPs. The representations are yes, no in the sense, not that you're asked to sort of say yes or no, but rather it's a pair of representations, one of which is a positive representation as to a status, and the other of which is a negative representation as to that status. And in some cases, those representations are reasonably flat. In other cases, they're reasoned, or they're qualified, I guess I should say, based on the nature of the interpretive guidance. There's 5 sets of pairs. The structure is basically laid out for you on this slide. You start with whether or not you're a U.S. person. Effectively, if you represent you're a U.S. person, you can stop. You're done with the letter. If you represent you're not a U.S. person, then you go to the next set of questions, which are you an affiliate conduit, or are you guaranteed by a U.S. person? You answer yes or no, make yes or no representations as to those 2 statuses. And then if you represent that you're a non-U.S. person who does have U.S. person guarantees, there are 2 additional sets of questions designed to elucidate whether the nature of those guarantees are such as to bring you within the scope of Dodd-Frank when dealing with certain other non-U.S. counterparties. Just to point out, there is also a definitional appendix, which is designed to be as informational as we could make it in a very short document that could be easily digested and loaded up to an ISDA Amend pop-up. Just so that you don't miss it, on the letter version, it is at the end of the letter. And on ISDA Amend, it's a pop-up that you bring up by clicking on a link that identifies itself as the definitions link. Definitions were a bit of a challenge, again, because of some of the softness of the CFTC's own definitions. In a few places, rather than defining a term, the CFTC provides factors that they'll consider in making their own determination as to whether you're a U.S. person or the like. Generally, where there was a concrete set of factors that we could reproduce, we produced them for you in the definitional appendix, and they're there for you to read and digest. In many cases, though, there was significant gloss that was not produced in a manner that could be reproduced in the definitions appendix. So what we did there was basically provide a number of footnotes in the definitions to point you to places where there's further gloss as to how to interpret the various factors or definitions. So, for example, when you look at the definition of affiliate conduit factors, the 4 factors that the CFTC provides for affiliate conduit, we provide a footnote sending you to the discussion as to how the CFTC weighs those factors, which is really kind of at their discretion. And we provide footnotes as to what they mean by majority ownership for purposes of those factors and the like. Similarly, for the U.S. person factors, we provide various footnotes throughout to highlight interpretive issues that may come up for particular parties and point them to the particular page of the interpretive guidance where they can find the CFTC's discussion. So we try to make it sort of leave a trail of breadcrumbs for you to help you assimilate some of this, some of the more complicated guidance. All right, into the substance of the representations. First, U.S. person status. The first section of the letter allows you to represent whether a U.S. person or not. We've reproduced the basics of the representations on this slide. Note the definition of U.S. person as the CFTC talks about it in the interpretive guidance says a person will be deemed a U.S. person if they meet one of the following 7 factors, and then they say U.S. persons generally include but are not limited to people who satisfy those factors. So for purposes of the representations, we crafted a strategy around that basically asks people to look at the factors and to effectively represent, one, whether they reasonably believe that they fall into one of the categories that the CFTC enumerates. So I think I said factors, but they're actually categories. It's a reasonable belief representation there because as you become familiar with those categories and digest them, you will recognize that in many cases, a buy-side participant can determine whether it meets one of those categories based on information that it already has. But in a number of cases, the participant, particularly for pooled investment vehicles, may need to go out and get representations by investors or somehow diligence the status of their investors. And because they may be, relying on representations that they've received, we thought that we determined that a reasonable belief standard was going to be the appropriate standard to provide representations that could be relied on, but that could also be made. And then secondly, because the interpretive guidance again, leaves open the possibility that somebody who does not fall within one of the U.S. person categories could be a U.S. person. There's also a good faith belief representation that's included, that the party believes in good faith that they would not otherwise be categorized by the CFTC under the interpretive guidance as a U.S. person. There really isn't a lot other than the categories and a little bit of gloss about the categories, guidance in the interpretive guidance about U.S. persons, but because it is an interpretation rather than a rule, the CFTC has left itself discretion to provide further guidance, and we covered that with this good faith belief. If you're representing that you are a U.S. person, it's a little bit of a simpler rep. You simply represent that you reasonably believe that you are a U.S. person. You don't fall into one of the you do fall into one of the U.S. person categories, or are otherwise a U.S. person. And there's a check the box on the letter. You can check one of those two boxes. Obviously, you should only check one of them, not both. Okay, so that's U.S. person. Additional representations. In case you're not sure where we are, we're on slide number 9 in the deck. So if you have represented that you are not a U.S. person, you then proceed to the second section of the letter. The first representation that you are asked to address is, and I guess I should say, this section is intended to address situations where a person is not a U.S. person, but they have relationships to third parties who are U.S. persons, such that a non-U.S. person counterparty they're facing still needs to treat them as being within the scope of Dodd-Frank. Again, that really means that you're a affiliate conduit for U.S. persons or a guaranteed affiliate. You have U.S. person guarantees that are guaranteeing your swap obligations. So for affiliate conduit representation, again, a pair of yes/no representations. A couple of things to note. The term affiliate conduit and conduit affiliate are used interchangeably in the interpretive guidance. The affiliate conduit term is defined by reference to 4 factors. We reproduce those 4 factors in the appendix. The CFTC really does not give you a bright line test here as to what an affiliate conduit is. You could think of those 4 factors as kind of coming down to two issues. One is your purpose to enter into swaps offshore and then to transmit the risks and benefits of those swaps onshore to U.S. persons, meaning you're effectively a hedging affiliate. And then the second set of factors, and this is captured by 3 separate factors, really goes to kind of affiliate-ness. And the CFTC, unfortunately, doesn't provide real guidance as to how you kind of weigh those factors, whether one factor is necessary and, versus the other. It's a little bit more of a when you see it kind of guidance, but they, for the sake of giving some sense of when they think they see it, they put out these 4 factors. And so here, we were unfortunately given pretty tough territory to work with. The representation is basically just a reasonable belief representation as to whether you would be categorized as a affiliate conduit based on having reviewed the 4 factors and based on the interpretive guidance as a whole. So again, it's a baseline reasonable belief representation, and you are commended to the factors at the back in order to help you come to that belief. Guarantee representations. The next set of categories is asks whether a person is guaranteed by a U.S. person. There are a couple of issues to note in terms of these particular representations. First, the definition of guarantee. We do provide a definition of guarantee in the back, in the appendix. It is designed to capture a broad concept of guarantee as discussed by the CFTC. In the CFTC's interpretive guidance, the concept of a guarantee is actually discussed in two separate sections of the release, and the language in those two separate sections is inconsistent. In one section of the release, the language indicates that the concept is a concept of recourse. So, wouldn't necessarily have to say guarantee, but something like a guarantee or a keep well or an indemnity agreement. In the other section of the release, the discussion is much broader and picks up concepts of anybody who basically takes economic risk by virtue of providing recourse or other credit support to the swap counterparties. So that arguably picks up collateral providers. And in the absence of further guidance from the CFTC explicating what they mean by a guarantee, and believe me, we did try. We took the broadest of the two, or the broader of the two approaches, in order to provide reps that would effectively cover all of the relevant situations. So the cross-border representation letter is intended to work for all purposes of the interpretive guidance as relates to the question of guaranteed affiliates, both for swap dealers who need to know if there's a guaranteed affiliate to know whether the transaction level requirements apply, and for non-U.S. non-swap dealers who are more concerned with questions of aggregating swaps for purposes of registration purposes. About the nature of the guarantee, the other place in which the interpretive guidance is a little bit vague is what a guaranteed affiliate sort of means. Again, there's sort of different discussion in a couple of different places. In one discussion, the guaranteed affiliate concept is very clearly described in terms of a particular swap being guaranteed by a U.S. person. In another section of the guidance, the CFTC uses the term guaranteed affiliate more generically, which sort of has led questions as to whether it's a swap-specific determination in all cases, or whether somebody could be a guaranteed affiliate even if the particulars, for purposes of dealing with the requirements in connection with a particular swap, even if that particular swap wasn't guaranteed by a U.S. person. So that was an interesting challenge, and we addressed it effectively by providing a rep that we think works to provide all of the information that a counterparty would need and could reasonably expect to get in a representation. And there's a little bit of interpretation that a receiver needs to apply in taking that rep. But effectively what we did is we tried to create a rep that would work as a swap-specific rep, but that would also create a baseline kind of to establish more broadly what the status is for the pair of parties. So what it effectively does is ask you to make a deemed rep, which is repeated every time you enter into a swap, and you kind of pick up front whether that deemed rep is going to be I am guaranteed or I'm not guaranteed, and that's deemed repeated every time you enter into a swap with the same counterparty unless you notify them in advance otherwise. So it provides swap-specific information, but it also provides kind of information as to generally, for swaps under that relationship, will guarantees apply or not, and then, further provides flexibility for a party if there's generally you have guarantees by a U.S. parent, but for whatever reason one swap is not guaranteed by that parent, you can notify your counterparty of that fact and avoid making a incorrect deemed representation. And again, it's we leave it to the parties receiving those reps as to how they're going to interpret guaranteed affiliate in the light of the CFTC's discussion of that point. But we think the rep gives you all of the relevant information. Okay, and then lastly, for a non-U.S. person who is represented, and I'm on slide 12 now, for a non-U.S. person who is represented that they do have guarantees that are provided by U.S. persons, there are two additional sets of information and pairs of representations that are requested. Those are really more for non-swap dealers who are dealing with aggregation and the like, but depending on the nature of your affiliations and your guarantees, you may be within scope for those counterparties or not within scope of Dodd-Frank for those counterparties. And the two sets of information are whether the guarantors, the U.S. person guarantors who are providing those guarantees, whether or not they are financial entities. And the financial entity definition takes you back to the Dodd-Frank statute. It basically picks up swap dealers, MSPs, pooled investment vehicles, I believe ERISA plans, and then anybody else who is engaged in activity that is predominantly engaged in activity that's in the business of banking or financial in nature, and there's a whole long story about what that means. And then secondly, whether you have any swap dealer affiliates, because there is a sort of a safe harbor, even if you are guaranteed by U.S. persons, if you are an affiliate of a swap dealer and are not yourself dealing swaps above the registration thresholds, there's a safe harbor for those situations, and so we have provided a pair of representations for that. Lastly, a couple of words on ISDA Amend, and then I'll turn it over to Rich. The ISDA Amend will provide an essentially identical set of representations, or I shouldn't say essentially, an identical set of representations, which can be provided electronically to subscribing counterparties. The look and feel of ISDA Amend has been, designed to work with their front end and to be intuitive. The substance of the way the ISDA Amend platform works is you check boxes. Next to each box, there's a little title. That little title matches up to the little title of the representation that is provided on the paper version of the rep letter. So if you've got the paper version in front of you and you look at the U.S. person representative's representations, you'll see the first representation has a little title that says not a U.S. person, and then the second one has a little title that says U.S. person. Those titles have been reproduced on or will be reproduced on the front page, if you will, of ISDA Amend with a checkbox next to them, and then you can click on those titles in order to bring up a pop-up that will provide you the text of the representation itself, which will be identical to the text that's on the paper version. And by checking that box, you make that and signing the bottom of the ISDA Amend questionnaire, you make those representations. Then you can deliver them to counterparties through who are provided to you as a drop-down menu on ISDA Amend. ISDA Amend is available free to anybody who wishes to onboard it for this purpose. It is not restricted to persons who have signed up to the August 2012 protocol or the March 2013 protocol, and there is no fee involved. So with that, I will turn it over to Rich to talk a little bit more about the details of ISDA Amend and the structure and architecture.
Thanks, Jeff. For ISDA Amend itself, we're going to show you a snapshot of the cross-border rep here. And this is going to be a view of our interface of how we're going to be providing these details. So a little bit of information beforehand is for clients, obviously, that are already on ISDA Amend, do not have to re-register for this information. This is going to be leveraged off your current entity information that's on the platform itself already. And the details are all you'd really need to do for existing clients is to go into the portal and click on this particular area of this page to make your reps. And it'll pull in all the existing information with your true legal name. and the LEI/CICI or pre-LEI information that's going to be listed on this particular page. For new clients, I would suggest that you onboard the platform and register, get access, enter your entity information on the platform, but one prerequisite would be to have an LEI/pre-LEI on the platform. This is just to ensure adequate and efficient client info to your counterparties when you're exchanging these details. So this is a mandatory field, and will require you to have this in order to fill out the reps. Now you can find, most of the clients that have done for Protocol 1 and 2 have gone onto the CICI utility to receive an LEI/pre-LEI for CICI, but there are other LOUs right now that you can provide that same information because they are in the same ISO standards as the CICI identifier. So with that being said, the next step would be to go in and enter this information on the platform. So existing clients obviously just go onto the platform, provide those reps, and you'll see this view here. Basically, once you go onto this page, you'll have your true legal name, your LEI, and then you start clicking your representation. So question one, as Jeff mentioned, you can only select one of the two, right? You either are not a U.S. person or you are a U.S. person. If you click that you are a U.S. person, you don't have to fill out anything else. If you are not a U.S. person and you click that, you will be required for the additional representation of non-U.S. persons. So you have to fill out A through D and click one or the other. And again, as Jeff mentioned, each one that is underlined and highlighted in blue, you'll see that these are all hyperlinks to what the details and what Cadwalader provided as riders and information. It's going to be exactly what they have provided on the paper version. The last part of this is the relationships. So existing clients will have that access to the platform will have the existing relationships that if they had for Protocol 1 or Protocol 2, they can distribute to those dealers. For new clients, they'll have to add these or select these dealers. Now we have over 50+ dealers on the platform for selection, and you'll be able to distribute that information and permission your counterparty this rep specifically. So for existing clients, all you'll need to do is go in and fill out the information and then just apply your cross-border representation. For new clients, I would suggest you fill out this information, and you don't need to fill out for Protocol 1 and 2, like Jeff mentioned. That is not required if you're not a U.S. person, but if you are a U.S. person, we're going to recommend if you didn't fill out Protocol 1 or 2 to do that as well. And that would be part of our live webinars that we're doing for demos at Markit. So a couple other things for enhancements is just to give you a bulk upload feature as well. So if you have multiple entities to bulk upload to give this representation for existing clients, we can do that as well for you. For new clients as well, we can bulk upload those details for all your information that you have. So if you have more than 25, there is a bulk upload template. We'll also have a process flow or a toolkit for you to walk through this process as well on our website, and we'll also provide that with ISDA for this webinar, the details of what to do if you're not an existing client or an existing client and what the process flow would be going to entail. Lastly, the help menu on ISDA Amend will also provide the full documentations of the cross-border representation that is on ISDA's website and the details and definitions as well. We'll have support, ISDA Amend support team as well, reviewing and assisting on your client information and walk you through any process that you need on the platform if you do have any questions on technical questions on the process flow on ISDA Amend. Obviously, the legal information would be referred to your counsel, and aside of details, we can only provide you those hyperlinks to guide you.
Okay, with that, we will turn to some of the questions. We've had some good incoming questions. So, Jeff, is there any questions in particular you want to start with?
Yeah. So, and as we anticipated, a lot of these questions are about the interpretive guidance itself rather than the new U.S. person letter. I'll field some of those selectively and wade in where I can. I hope questioners on the call understand. I haven't memorized all of the possible permutations under the interpretive guidance. I'm not sure that anybody has, although somebody's probably come up with we've got some nice spreadsheets to go through the different permutations. And of course, that understand is not legal advice. Okay, so one question: can you describe the key differences between the initial U.S. person definition that was provided on a temporary basis back in January and the final guidance? Very good question. Thank you. The initial U.S. person question was designed to be usable without having to get representations by counterparties. So it was limited to information that the CFTC thought counterparties would generally have. And the new guidance, primarily differs in that it moves to situations where a party might have to provide representation. That comes up really in two places. Well, first, principal place of business. Under the old guidance, for a corporate, you were a U.S. person if you organized in the United States or you had your principal place of business in the U.S., but it didn't apply to funds. In the new definition, funds are also asked to identify themselves based on their principal place of business, and there's a fairly lengthy discussion in the guidance as to what principal place of business means in the context of an investment fund. Generally speaking, it probably directs one to the location of their investment manager, but there are some other factors to consider, and there's a bit of a weighing exercise that has to be conducted to determine where your principal place of business is. The other place that this comes up that's going to be of significance, again, with pooled investment vehicles is pooled investment vehicles are deemed to be U.S. persons if they're majority owned by U.S. persons. And there's a bit of a look-through that attaches to that. You look to the first level of ownership, but basically if you're an owner is an affiliate, then you have to look through the affiliate up the chain to determine whether you've got 51% ownership. That may require, getting representations from investors. And then also, this is a narrow category, if you are a corporate, but you are a form of corporate that has unlimited liability, such that your investors or owners have a liability for your swap obligations. If those investors or owners are majority U.S. persons, then you're also picked up. I think those are the primary differences. There may be some minor differences around trusts and estates, but generally that's fairly intuitive. I should also say there's some guidance around ETFs and other pooled investment vehicles that trade on the secondary market, where there's a carve-out for investment vehicles that are basically that sell and trade only offshore. That guidance was primarily provided in the discussion rather than in the categories. It was imperfectly lifted into the categories, but that's another difference from the old definition. There's a question about EMIR and ESMA reporting, which I am going to apologize for and skip because I'm not an EMIR or ESMA lawyer. Question about requirements between non-U.S. swap dealers and U.S. person, where the U.S. person is claimed exemption status. I'm not
End user exemption?
End user exemption, maybe. Yeah. I mean, generally speaking, a non-U.S. swap dealer that faces a U.S. person is subject to the full scope of Dodd-Frank requirements. That if that U.S. person has available to it the end user clearing exception, then that exception is available to it.
So that doesn't impact the need for the swap dealer to know
if they're a U.S. person, right? Does a corporation need to fill out this letter if we're considered a U.S. person and only trade with U.S. swap dealers? That's really a practical question. I think it may very well be the case that, U.S. swap dealers will be able to identify corporations who are U.S. persons as such. And, particularly if you've done the full set of Dodd-Frank protocols and have all your documentation up to speed, you may very well be able to get by without filling out this letter. On the other hand, if you're a cautious sort and want to be sure, it probably doesn't hurt you to make the representation. And it may be the case that some cautious swap dealers may ask you for the representation. There's a question about dealing with non-U.S. branches in jurisdictions such as India. That's a fairly complicated question. But it's an opportunity for me to note to you. There is a second letter that is, Catherine, is that published? The bank letter?
It will be published on Monday.
There is a second letter that ISDA will be publishing on Monday. That is a letter for U.S. banks that have non-U.S. branches. And that representation letter is designed to establish when a trade is deemed by the CFTC to be a trade with a non-U.S. branch. It's a more complicated question than just, what the document says is your counterparty. And so U.S. banks will be able to use that letter in order to establish with their counterparties which of their branches are deemed to be good non-U.S. branches and when a swap will be deemed with that branch. And then secondly, there are a number of jurisdictions, India would be one of them, where a non-U.S. branch can comply with local law, a non-U.S. branch of a U.S. swap dealer and its non-U.S. counterparty can comply with local law in lieu of the Dodd-Frank transaction level requirements if the bank on a global basis meets certain requirements as to the volume of its swaps within CFTC jurisdictions versus non-CFTC jurisdictions. And that rep letter will provide representations as well that can be used in order to establish whether that's applicable to a particular trade. There's a question about Markit. Are you guys going to be ready for the onslaught?
We're going to try. We're going to try. As long as you guys tell us and feel that there are situations where your clients need more attention, let us know. We can help you out, do assistance in live webinars, education, or anything like that you guys need from our end.
Okay, scope of representation. A couple of questions about this relating to swap dealers. We had one commenter ask about the reporting requirement, whether that U.S. person field is going to be considered mandatory or optional for purposes of reporting going forward. I actually don't have new color on that question. It's part of the Part 45 rules, but it may very well be something where the CFTC provides could provide a little bit of relief. Generally speaking, if you're a registered swap dealer, particularly if you're a non-U.S. swap dealer, you are going to want these reps from your counterparties unless there are certain circumstances where your counterparty is a U.S. person. But I think one can expect generally as a rule that non-U.S. swap dealers around the globe, if they're registered with the CFTC as a swap dealer, are going to want to get these representations or otherwise be able to establish how their counterparties line up on this new guidance. Will the rep letter be tied to the questionnaires on ISDA Amend? I think Rich has already answered that. Yep. They will not be. Is this an advisor level or fund level set of representation? Basically, the U.S. person status attaches to the account or the fund, not to the advisor. Although the location of the advisor may very well be relevant to answering the question whether the fund is a U.S. person or not. The slides, I think, will be made available on ISDA's website, and I think will be downloadable.
Yes.
I think this is a question about ISDA Amend. Non-swap dealer, non-MSPs generally will have access to the free part of ISDA Amend, which will allow them to click the representations they want.
Well, what we've also reached out to a lot of non-registered swap dealers for access on the platform, and if they want to be on the list to be a selection, there is a process. So feel free to contact me directly. For those as an end user to view for non-registered swap dealers to use the platform right now, it is free, but you can only select dealers. So the process flow is a little reverse on the other side. If you want access to be a selection, please contact me and we can get you on that list.
And Jeff, just to highlight where that could be relevant, if you're a currently non-registered swap dealer, but you're assessing the U.S. person status of your clients, for potential subsequent future registration, right? That could be,
right.
That ability to collect that information on ISDA Amend could be very useful.
Right.
Correct.
So free access generally to non-swap dealers if they want to be on the, basically on the delivering side of ISDA Amend, where they can select to deliver. They, I think, can also receive representations from the subscriber group. But if you want to be receiving representations from broad groups of buy-side counterparties, then talk to Rich or one of his colleagues about getting onboarded onto the sort of the subscriber side of ISDA Amend.
Right. Okay. I think we're at the closing time of the call. We really appreciate everyone dialing in and the questions. We will post both the recording, we'll circulate the link to the recording and post the slides on our website later today. Thanks very much, everybody.
Ladies and gentlemen, that concludes today's conference call. We do thank you for attending. You may now disconnect your telephone lines.